Well, I have a story about a case that was decided by the First Circuit Court of Appeals last week involving arbitration. I think it has some interesting applications for entrepreneurs and business owners. So the facts of the case comes out of Puerto Rico, where a hotel worker claimed that subject to sex and age discrimination, and he filed a charge with the EEOC, and subsequently he claimed that his employer, which was the Ritz-Carlton Hotel in San Juan, retaliated against him. That's prohibited by labor laws, retaliating in response to the filing of a claim. He was ultimately dismissed, so he brought suit in federal court. He did sign an arbitration clause twice, an arbitration agreement twice while he was employed by the company, and the agreement basically says that within 1 year he may file any complaint relating to discrimination or retaliation in arbitration. So what's interesting, the exact language was, I must request arbitration if I wish to challenge my termination for any reason or for management decisions that I believe are discriminatory or retaliatory.
Interesting. Now, I'm assuming that's a standard clause that all employees sign? Or?
No, it's not standard, but over the last...
Or for this entity, I'm saying. For this entity.
Yes,
and in other words, they wouldn't apply to this one individual.
Right. And over the last several years, the United States Supreme Court has strengthened the enforceability of arbitration clauses and has applied it in employment contexts. So even though this is an employment situation, it has relevance not only to listeners' employment relationships, but also relationships with vendors and other parties. So,
and also from an industry perspective, probably fairly common that these things happen within the hospitality industry, hotels, restaurants, etc.
Yes, exactly. So what the interesting twist here is the claim that the plaintiff was bringing, if this clause is not enforceable, would be subject to a 3-year statute of limitations. So in effect, the agreement, the arbitration agreement, attempts to shorten the statute of limitations on a claim of retaliation. So the question is it valid, and who decides whether it's valid? So the district court dismissed the case, and the First Circuit affirmed on different reasons. So the court decided that whether or not it is the 1-year clause is going to be valid under Puerto Rico law has to be decided by the arbitrator. It's not decided by the judge. So
the arbitrator making the decision as to whether or not the employment agreement is even enforced.
Even whether that provision is valid or not.